I'm Lane Harvey. I represented Lynn Feltmeier in now the landmark case of Feltmeier versus Feltmeier, decided by the Illinois Supreme Court in 2003. That case may be found at 798 Northeast 2nd, 75. That case recognized in Illinois for the first time the use of the tort of intentional infliction of emotional distress in a domestic violence situation. Simply by way of introduction, the elements of that case are, first, that the conduct of the defendant must have been intentional. Secondly, that the conduct of the defendant must have been outrageous. Thirdly, that the conduct must have been done either with the intent of causing distress or with the knowledge that it was reasonably likely that it would. And fourth, that it did in fact cause distress. Now, when you read the case, you'll see that the Illinois Supreme Court lays those elements out very clearly, and then they trace those elements through all of the issues and through the complaint that we had filed in that case. Now, Feltmeier wasn't the first case to recognize that intentional infliction of emotional distress may be a continuing tort in this context. But in many respects, it was the most important case to have done so. And we'll talk a bit about why that's true as we go through. To begin with, let's talk about the plaintiff, Lynn Feltmeier. Now, Lynn and Bob Feltmeier had been married for about 11 years. They had been divorced, and frankly, they were divorced before Lynn came to see me. I didn't represent her in the divorce. Lynn came to see me for what are typically fairly common post-judgment matters, including a failure to pay child support, his continuing refusal to honor the visitation agreements with the children, and things of that sort. As I got involved with Lynn in the case, she started telling me things as we went through preparation for the case of her treatment by Bob during the course of the marriage. Now, to understand the significance of this, you have to understand a little bit about the two of them. First of all, Lynn is maybe 5 feet 2 inches tall and might weigh at the most 110 pounds. Bob is 6'3", and he weighs about 230, and he is in very good physical condition. He works out, he's very muscular. The other thing that Lynn kept telling me was things related to his treatment of her since the divorce, which led us then to talk about how he treated her prior to the divorce. After they were divorced, he would continue to come around her house. At one point, he sabotaged the spa that she had on her deck outside the house and eventually admitted to doing so. He broke into her house and did things to her computer, as she was a drug salesman, a drug salesperson for a pharmaceutical company. He erased records from her computer. As we got more and more into it, Lynn advised me of his treatment of her through the marriage. The post-divorce was, of course, raucous because there were particular requirements imposed upon Bob that he frankly didn't want to meet. When you deal with people of his personality type, and he's what you could only determine to be a bully, and one of the reasons that I was in this case and have been in other cases similar to this is, frankly, I hate bullies. And the only difference between one and the next is the Social Security number and the birth date, and he was no different than the rest. When Lynn would seek to enforce the order of the court at the conclusion, after the case had been concluded, he resented it. He called her, he cursed her, he harassed her in other ways. As we got into that, Lynn talks to me about things that happened during the marriage. He was physically abusive to her to the extent that he would strike her. There were photographs where he had struck her in the face with a closed fist black eyes. There were bruises that he would leave on her body because he would most typically hit her in places that would not be exposed, such as her back, her abdomen, her legs. He would keep her from her family. Those kinds of abusive conducts were very clearly detailed in a very lengthy complaint. The one thing Lynn did that she ultimately disclosed to me is she kept a diary of these abusive incidents. And so our complaint, when we filed it, detailed the matters from her diary, including the physical abuse, the emotional abuse, the control that he maintained. Frankly, the deal that Lynn got in the divorce case and resolving the divorce case wasn't that good. The reason for that, she was afraid of him. And when we started talking about things like enforcing the divorce judgment, she was afraid of him yet. As we got into this more and more, and the harassment continued through the case, I discussed with her the potential of bringing an action against him. Now, the reason that I suggested intentional infliction of emotional distress is because it is an action that I had used before in similar circumstances. Now, the procedure for this case, getting to the Illinois Supreme Court, is of some interest. When we filed the action against Bob in the Circuit Court of Jefferson County, Illinois, Bob's attorneys filed a motion to dismiss, claiming that the statute of limitations had run on most of the actions, most of the acts that we claimed that he committed against her. Our response was, of course, that it is a continuing tort. The trial judge accepted our position and refused to dismiss the case. Bob's attorneys asked, pursuant to Illinois Supreme Court rules, that the court certify questions for interlocutory appeal on the basis that the answering of those legal questions would facilitate a termination of the case. Frankly, I was absolutely ecstatic when they asked to do that, because it would finally get me to a court of review that would have occasion to consider these very important questions. The three questions that the court certified was, first, whether the complaint that we filed in the case actually stated a cause of action for intentional infliction of emotional distress. Secondly, whether our claims, based on conduct that occurred more than 2 years prior to the filing of the action, ran afoul of the statute of limitations. And thirdly, whether the boilerplate release language in the marital settlement agreement and judgment somehow released these claims. The first two of those questions were what the case's primary importance was based upon. First of all, did we state a claim for intentional infliction of emotional distress? Well, both the appellate and Supreme Court said with an exclamation mark that we did. The claim made by Robert was that his conduct toward her was not outrageous because it was in a marital context. In some detail, the Illinois Supreme Court simply said that's not true. The Illinois Supreme Court, the Illinois Appellate Court concluded, and if I may use their words, that such conduct would be regarded as intolerable in any civilized community. Therefore, it was outrageous. Therefore, we stated the claim. Secondly, the court determined that because of the nature of the injury that Lynn sustained, the so-called battered wife syndrome, a form of post-traumatic stress disorder, and because of its being a product of the accumulation of a continuing pattern of conduct, that the continuing violation or continuing tort rule should apply. That is, all of Robert's pattern of conduct from the first instance of abuse to the last was one act, effectively, for purpose of the statute of limitations. The statute of limitations, therefore, did not begin to run until the last act that he committed in the course of this pattern. And indeed, our action was filed in the Circuit Court of Jefferson County in the same month he completed the last act. The Supreme Court, in the opinion that you will be discussing, went through at some length the distinction between the separate courses of conduct and a continuing tort to distinguish the difference, and concluded wholly that it was a continuing course of conduct, therefore the statute had not run.